All right, we are now back for week 6, and ironically, we are talking about negotiable instruments. Look at that. Yeah, there's your prop for today. Um, Negotiable instruments are just a specialized type of contract. If you have a loan, if you've dealt with a check, those are all negotiable instruments. They must meet certain conditions to qualify as a negotiable instrument. So you have to have the basic 4 elements of an enforceable contract. Again, those being legality, capacity, the agreement itself, offer and acceptance, and consideration. In addition, there are like 6 other criteria. It's got to be in writing, some certain, no conditions, etc. You'll see those are set forth in your book. Now, these are a negotiable instrument. It's actually a very old concept. The idea is that rather than carry a bunch of money around with you to engage in trade and commerce, there would be a document, a negotiable instrument that would be as good as cash. And in fact, cash is a negotiable instrument signed by the party to be charged, things like that. There are 2 basic types of negotiable instruments. An order instrument, you'll see this on the document itself, on the check, paid to the order of. That's an order instrument if a name's put in there. A bearer instrument is where it's the person who has the instrument, meaning the check, the promissory note, or whatever, is able to enforce that instrument. It's not made payable to them. It can be the payee line can be blank or cash or whatever. And this is very common in loans which are assigned. And we talked about assignment earlier on. When you assign a loan, normally to make it more fluid and transferable, it'll be a bearer instrument, so anybody has it. Can't enforce it. There are liabilities that go along with a negotiation if you were to endorse a note, or if you are signing on a check, if you're the drawer, etc. There are liabilities and warranties associated with this in case of forgeries and things like that. This is a term I want to make sure you understand this here about assignee, holder, and holder in due course. Assignee, think that's a common law contract. It's a term that's used in common law primarily. A holder, that term is used in negotiable instruments, a holder of an instrument. But at the end of the day, the holder is the same as an assignee. A holder steps in the shoes of the party that transferred them the instrument. So if there's a problem with the original deal, if there's fraud, the holder is going to be liable for that activity. Now, if a holder has achieved a status of a holder in due course, and that there are 3 criteria for that, you'll see basically good faith without knowledge that there's a problem in the instrument, etc. You'll see that in your book. That status protects the holder from some but not all claims. You'll see the distinction between personal and universal defenses. So make sure you're aware of that as you look at your materials. Those are personal and universal defenses. All right, so bank and customers, it's a contractual relationship. The bank is going to be your agent. They have to pay. Now, there are a lot of technical rules here, but among them is that you have a responsibility to check your bank statement to ensure that there isn't any goofiness on your bank statement. Understand how to make a stop payment order. You can do that orally or in writing, but your contract with your bank can change that. And remember, a stop payment order doesn't mean that the check is destroyed. That a person can come back after 6 months and try to run the check through, that kind of thing. So keep that in mind. Big problem if anybody ever asks you to do or sends you a certified check and wants you to send them money, Western Union, run like Forrest Gump. Keep on running away, because that is normally a sign of a scam. Very common on eBay sales, on Craigslist, the certified check scam. And the problem is you deposit the certified check, you think you got the money. You don't, because the process takes a while. But we are talking about commercial paper, and there's a number of videos on this. So when you hear the term commercial paper, you're thinking, oh, negotiable instruments. This is what makes the whole world economy work, and what was the downfall as a result of the mortgage meltdown back in 1998. But understand how our mortgage works Real briefly, two documents: a debt instrument, which is the note, which is normally a negotiable instrument, and then the security instrument, which is normally a mortgage or deed of trust, which is recorded with the county where the property resides. You'll see there's some information on this entity called MERS. And just as an aside, this is in the security instrument. Normally the lender's the same at the beginning, but it's too much of a hassle for the banks to keep on changing the name on the security instrument by keep on re-recording, so they plugged in an entity called Mortgage Electronic Registration System. Quite controversial. Some states, including Washington, has raised some serious issues with use of that agent by the banks. Important to understand that if you are a homeowner, you own the home. This isn't in the state of Washington. The bank or the lender has a lien, more or less a lien on the house, and to get the collateral back, they got to foreclose on you. And then in the state of Washington, two ways to foreclose: judicial, non-judicial. These are described in the materials. But this ultimately leads to the whole chaos of securitization and how these negotiable instruments are supposedly bundled into mortgage-backed securities, and then people invest in, depending on their level of risk, and how this was abused and is hugely problematic.